going to call Vanita Lloyd versus Lamar Lawrence. Case number C22G2833. Who's here on this?
Anthony Lumpkin for Miss Lloyd, plaintiff.
Okay.
Never showed. Guy never showed.
Is Lamar Lawrence here?
He never showed. He's 6 hours late.
Okay, well, let me see here.
It's termination. We're not waiting for money. Should be able to be pretty easy to just dispose of it. This guy's majesty couldn't be bothered to show up for 6 hours.
Well, I don't have a real way of verifying that because I've had a
There's a
swap of court recorders in the middle of the day.
If he cared, he would have come in the middle of the day and he would have checked in and waited for the new court reporter. So either way, he's a dud.
You know, Mr. Lupkin,
Yeah.
I got to tell you, the case is a dud.
Well, if you want to blindside me with some scolding, I'm ready. I don't know what the heck's wrong with it. I don't appreciate always having bad news all the time.
Turn to your notice to quit.
Yeah.
See it?
Yeah, what about it?
Paragraph 1 is blank.
Paragraph 1.
They either have to check the box that refers to the statute, or they have to check the box that says other and fill in that blank.
I think she checked the box. Maybe it came out too faint. Maybe she used a Sharpie. A yellow one. I mean, I understand like the punished landlord. This nice old lady. She's a nice church-going black lady. She's everything fair and square. She doesn't cheat anybody. She's a sweetheart. And I know you like to slam everything landlords make mistakes.
I like to follow the law, Mr. Lumpkin. Well, and the law is that if the notice to quit or demand for possession is defective, then the court does not have jurisdiction to hear the case. So that's what the law is in Michigan. And I don't care what race or what church or how many times she goes to, I think I remember her appearing here years ago.
Yeah.
But let me, I'll go ahead and cite the, would you like me to cite the?
If you're going to turn her down, we'd like to have it in writing as to what was wrong, so I can give it to her and show it to her. She's the one who sent the notice. She has to know that.
Well, you're going to show her that she didn't check a box, right?
Well, if you say in your notice, relief denied for lack of checking off the box on number 1, then, that'll be good. I hate to have had to wait 6 hours to find out something like this. So I was like, why can't they do the quickies first and argue with people about their guardianship and their mental problems and their autistic children through the day? This is something I shouldn't have had to hear all that daytime TV to find this out. It'd be different if we had success after 6 hours, but much as I like you, I like your sense of humor. I know you're very thorough. Why can't you go through all the easy stuff and weed these out and then, slap us with the dud news early so I can tell my client.
Mr. Lumpkin.
That's why I want to retire. That's why I'm about to retire. Go ahead. What's your question?
You going to retire?
Well, I'm only 68. I'm getting tired of this. But what was your question? I know I don't look that old. What was your question?
Oh my goodness! If you're going to retire, have you ever thought about becoming a court recorder so that you can stack the cases the way you think they should be stacked with all that legal experience and knowledge?
If there's anything that's wrong, that's categorically wrong, you'd think you'd have a moment to just weed those out right off the bat. It's a matter of consideration. It's not really to say. Like I say, I think you have a great conscience and a great social purpose and a great mission and a great spirit, so I don't want to knock it, but I just think that would have been nice to know. By grace of God, nothing better to do but watch Jay Powell and the Federal Reserve all day, so it didn't hurt. But in some people, it's probably wrecked their day having to wait this long. Didn't hurt me. I was at home, so. But I just think it would have been nice to know. So please issue the reason for your denial, so we can, or if you can adjourn it. I guess you probably can't, can you? Because you didn't put the right notice.
No.
Seemed to me like this is one of the punishments that these people who don't show up should suffer. Normally, if it's a defect, it's up to the defendant to bring it up. I don't know how, you ally yourself with the absent. It's different if the guy's present. God love you, but if he's absent, then it's up to him to say so. I think that's one of the problems we have.
Well, maybe Mr. Lupkin, maybe I'm like a machine.
No, you're a lot of fun.
Maybe I'm like a machine over at the community college when people take a test and they fill in the bubbles, So maybe I'm just kind of like a machine. If the right bubble isn't filled out, well, they're marked wrong on the test.
But the problem is that if there's no one there,
that could be.
Normally, the judge isn't the advocate for the absent guy. If the guy doesn't show up, you can say you don't have jurisdiction, but actually, you have jurisdiction. It's just technically not filled out right. It's up to the absent guy or his lawyer.
It's not filled out right, which means, well, let me flush that out.
You can decide how you want.
It's not filled out right, which means the defendant didn't get notice as to the purpose for wanting termination. The whole point of giving somebody a notice to quit or a demand for possession is for the landlord to be able to say to the tenant, hey, you didn't pay your rent. Here's how much you owe for a non-payment case. And of course, in a termination case, the notice is to say, here's why I'm kicking you out, or here's why I want you to leave. And that way, if you correct this behavior in a termination case, you could stay. Or if you pay that amount of money, you can stay.
There's no behavior that can allow them to stay. And number one is a standard statutory form. And the only reason why there would be occasion to check a box would be number two, which is the other, in case there's any other reason besides the standard notice. And so it seems to me like you're looking for a requirement that isn't there. I'm not sure the law actually requires that box to be checked. I think it only requires that other box to be checked.
It does. Well,
you're the judge.
It does.
That. You can rule that, and I'll tell my client it's another 30 days.
So why is this person? What's the notice to say? I mean,
it says whatever the standard.
Wait. Just read the paragraph. Read the paragraph. It's an incomplete.
I'm answering you.
Never mind the boxes. Read the paragraph. It's an incomplete sentence without a box check.
No, it's still complete. It's that statute. Unless someone checks other, that's what applies. And you're just imputing a requirement to identify that the standard language has to be reaffirmed by the landlord, which I think is a technicality that you're famous for, and I respect that. I know you don't want to see landlords get away with cheap, sloppy things, and they are responsible for what they do, and blah blah. But I'm just saying, in a case where it's standard language or other, check the box. It's standard language. Let someone check the other. So that's why I'm saying, if you want to put up the resistance, and say no, you have the right to do that. You're the judge. But I'm just saying that the use of the standard language and citation of the rule under number one is presumed unless someone checks a box indicating something other. So I'm sure that Judge Crawford or Judge Perry or some other judge, Judge Marsh, would understand that and wouldn't invalidate if the guy's absent and wouldn't even bother to show up, would not invalidate the whole thing. If the guy happened to be there and say, hey, this is wrong, I think he'd be entitled to, to be able to claim an argument, and then you could jump on it and say, I like his argument. Yeah, I'll give him a break, but he isn't even there. So number one, he isn't there to raise it, and we don't have standing to bring up his arguments for him. And number two, it's nothing in the law that says that you have no jurisdiction without that being checked off. It just says
that's not true.
Well,
check
I don't
out
know.
Park Forest. Check out the Park Forest case, Mr. Lupton.
Well, Park Forest, what? I need a citation. I mean, you know,
sure.
I mean, I'm not going to argue with you. If you honestly, in your heart, as an experienced landlord,
Forest of Blackman versus Smith, 112 Mish 421, 1982.
Oh, Mishap, you mean?
No, it's Michigan Supreme Court.
No, the Michigan Supreme Court would be 112. That was the 19th century. 112 Mishap, probably. Unless you said 412. You said 112, right?
Well, maybe they wrote it down and wrong in my bench book.
It's Mishap, yeah. Anyway, and it says, and you're saying to me that it says that if they don't check off box number 1, there's no jurisdiction.
Oh, Mr. Lupton, you know it doesn't say that.
Okay, well, you might want to.
You know the case doesn't say that. Listen, Mr. Lupton, I would love to have the opportunity to talk to you about this a lot further. And anybody could tell you, including yourself, that I dismiss cases for this reason habitually.
Yeah, I know, and that's why I appreciate you.
Routinely, habitually, routinely. So for me to do something different on this matter,
well, you're quoting a case. You're quoting a case, 112 Mishap. I didn't get the last. What was the last part again? That one last bit, 112 Mishap.
Oh my goodness!
I didn't hear it. It was faded out. Sorry. I enjoy bantering with you, but this is still, a little
much. It's a 1982 case, 421, okay. 1982.
112 Mishap, 421. Okay, there it is. Park Forest versus Smith.
Well, there's a whole line of cases there, but that's probably the leading case.
Yeah, well.
Notice requirements can be conceived of as 2 distinct conditions that must be met before the landlord may commence proceedings. The first condition is that the landlord convey certain information about his or her intentions to the tenant in a specified manner. That would be letting them know why you're trying to kick them out. The second is that they wait a specified time period.
Okay, but in that case, in Park Forest case, the defendant got notice to terminate, then they accepted rent afterwards. That was the problem. Nothing to do with this case. No one's accepted any rent afterwards. Not the same case. They made no mention of the fact that
Park Forest.
I'm reading it.
Well, there's a whole lot of things that Park Forest talks about. I got to move on, Mr. Lupton.
I'm just saying that.
But you got 21 days to appeal my decision. So we'll move on.
If you can please explain what basis was in your motion, that would be, in your dismissal, that would be helpful.
I told you. So this is the second time I'm explaining it, and actually the third time. Court lacks jurisdiction because the notice to quit was not proper. It did not inform the defendant as to why the proceedings were sought, and therefore the court lacks jurisdiction. In fact,
you can write that. I'm just saying that the Park Forest case decided the way it was specifically because the landlord accepted rent after sending a termination. So that case is distinguishable, and the reason why it was decided that way was not because the notice was deficient, but because he accepted rent, and that changed everything. So that's why you're relying on
appeal it. That box is up there. What does that mean, Marcia? That black box.
Oh no.
Is she the judge? Landlord waives the right to enforce a covenant by accepting rent. Slinsky versus Gutstein. That was what that case decided on. Nothing to do with that little box not being checked. So that's not a good faith extension of that case. I'm willing to, work with you, but this is not right. You can't use that case as a citation. Yeah, they accepted rent afterwards. No wonder the guy was confused. Park Forest. We had nothing like that. Our guy was a complete dud, and you're letting him ride the fumes of his dudhood by ascribing rights to him that are not in the law and not in that case law that you said. Can you hear me? Are you there? Hello?
I guess I'm in a meeting now. Person. The 12 person versus Jacqueline Johnson. KC, are we on?
Yes, sir.
KC
Yes.
22G 3448 LT. Who's here on this?
Are we done?
Yes.
I'm here, Judge.
I'm here as well.
I'm as who?
Jacqueline
Identify
Johnson.
yourselves for the record. Starting with the plaintiff. What's your name?
Requill person.
Spell that, please.
It is spelled REQUILLE. Last name person, PERSON.
Defendant.
Jacqueline Johnson.
Okay, so
JAC.
Mr. Jennings, let me. Okay, so Ms. Johnson moved in my property a little over a year ago, and we agreed that the rent will be $750. The state of Michigan pays $690 of her rent, and for the first 4 months, Ms. Johnson paid me the remaining balance, which would be $60 of her portion. And for the past 11 months, I have not received no payment from Ms. Johnson.
Well, have you applied for assistance, Ms. Johnson?
No, because my rent portion is $690 and I don't pay a portion. And my rent is paid through Becca Management. It's a Section 8 program.
Yeah. So what's the issue? Why isn't it paid?
My rent is paid. My rent is paid by Becca Management every month. $690.
Well, you know what? Ms. Person,
Yes, sir.
do you have your notice to quit in front of you?
Yes, I do.
You got the same issue as the last case.
What you said,
You-
what is not filled out correctly, Judge?
It is not. Look at paragraph 1 on your notice to quit.
Okay, when I went down there to fill it out, the clerk office actually helped me fill it out. So then we need to adjust that with the clerk office if they are going to be assisting us with filling out paperwork to fill it out correctly.
No. Number 1, they're not supposed to be giving legal advice. And there's a big blue sign that says that, okay? Now, if they're giving legal advice, I guess you need to tell me who you talk to so that I can, ask their supervisor about that.
Okay, so what do I need to do from here?
Besides that, wouldn't you have given her the notice to quit before you came down to the courthouse to file the action?
Yes, I did. I gave her a 30-day notice before then.
Yes, you did on May 5th, right? So what
Correct.
did you say that the clerk told you how to fill this out?
I said they assisted me on filling it out the correct way, sir. I didn't say they told me how to fill it out. They never gave me legal advice. I'm sorry, they assisted me on filling it out.
Well, I don't know exactly what you mean by assisted. I don't know exactly what that means.
Okay, so what exactly was wrong with it, sir?
Okay, paragraph 1. You see it says, your landlord, landlady, your name, is seeking to recover possession of property pursuant to, in the next line, you have left blank.
Okay.
You have to explain why you are seeking to recover possession of property. So either you check the box that refers to the statute, or you check the box that says other and you write in the reason.
Okay.
You see what I'm talking about?
Yes, sir.
You're not going to tell me that one of the clerks told you to leave that blank, are you?
No, sir.
Okay. Because if they did, you would tell me, right?
Of course.
So it's blank because you didn't fill it out. Is
Correct.
that true?
That is true.
All right. Because the notice to quit is defective, the court doesn't have jurisdiction to hear the case. That's, and I cited the law on that earlier, but if you want me to go through it again, I can.
Not at all. I've just filed another one.
The other thing I would point out, and this is not, I don't see a copy of the lease attached. Check out your complaint. You see your complaint?
Yes.
You see paragraph 2 of the complaint?
Yes.
It says attached is a copy of the lease or occupancy agreement.
Yes.
Well, you're supposed to attach a copy of that. You're supposed to serve her with a copy of that with the paperwork that you give the process server to serve. Okay?
Okay.
All right.
Have a great day.
All right. We'll see you all at some point in the future.